Gosh, hello my lovely humans. It is Friday the 19th. It's about 11 in the morning, and I just got notice about a Donna Adelson motions update. Apparently I'm a few days behind on this, but there was an article, there's several articles, but the one that I'm going to be referencing is from Court TV from September 16th by Lauren Silver, and I will link it below so you can read, but I'm also going to take screenshots so that you can read along with me. I'm not going to read every single thing verbatim. I'm going to be jumping in with context as needed. I watched the entire Donna Adelson trial from start to finish. I watched all of the juror interviews afterwards, and I watched all of the TikToks of all of the jury related things from the foreperson who came forward, which is actually related to this argument. So Donna hasn't just put an appeal. Now, I will just say that in any criminal trial, no matter what it is, the defendant could have been in 4K HD on camera saying their full name, social security number, and address as they committed a crime, and they'll still put an appeal after getting a guilty verdict. Okay, there's always an appeal after a guilty verdict, literally no matter what. So having an appeal after a trial isn't surprising at all. But Donna wants a full-on mistrial. She wants the last trial just thrown out. She says that the conduct of the jurors and the judge was just so appalling, it should lead to a mistrial. Now, Donna has, I will point out this before we get into the article, that Donna had made multiple motions to get Judge Everett off of her case. She did not like him. He was a very even-keeled judge. To me, he has been a very calm judge. He makes his record. He says things firmly, but he does have a certain bit of charm to him. And you want a judge that the jury likes, and you want a judge who is fair. She was found guilty on 3 charges. She was guilty of first-degree murder, guilty of conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. So conspiracy means she was planning and plotting and scheming with the intentional loss of life of another person. And that came to fruition. Dan Markel has passed on because of her actions. Then there is also solicitation. She sought out somebody to hire a hit for him. And first-degree murder requires that there be premeditation. She thought about, pre-planned, and acted upon things that led to Dan Markel's death. Just because you're not the person who actually pulls the trigger, I say this all the time because I want to make sure it gets out there, you can still get charged with that crime. Some people think that if they aren't the ones who do the doing, they won't get charged for the doing. So in the article, the motion for a new trial and for leave to interview jurors filed on Monday, Donna's attorneys claim she needs a new trial, deserves a new trial based in part on juror misconduct. So she wants to be let out of jail to personally be present and to be able to ask questions to the jury. The motion identifies jurors number 5 and number 7, both of whom came forward after the verdict to talk about their experiences. Juror number 7 did not reveal her name, but did post videos on TikTok saying that she was the foreperson of the jury. Donna's lawyer said that they want to interview her to ask her about her social media activity during the trial. Okay, so let's talk about that real quick. So juror number 7 is the woman here. I watched all of it. I watched all of the trial. I watched all of the start to finish of all of the interviews and all of the TikToks related to the trial. Yes, juror number 7, the foreperson, did make social media videos on TikTok during the trial. You're allowed to do that. You're allowed on social media when you are a juror. You're just not supposed to watch the news, because if you're watching local news, you're more likely to come across stuff about the case. You're not allowed to do research or discuss or look up anything about the case. And if you happen to come across anything about the case, you are supposed to report that. And if you're wondering, well, who actually does that? Lots of people. Lots of people will report, either they tell on each other, okay, because they want a fair trial. They want this done and over with correctly. And second of all, people will come forward to get out of jury duty. And next, just because you're on social media and on a jury doesn't mean those things coincide. If you're not into true crime, if you don't watch trials or follow local law enforcement things, you're not suddenly going to get it just because you got summoned to jury trial. You're allowed on social media. You don't suddenly come across it. I cover trials and do law and crime research all the time. My family knows nothing about anything that's going on in trials just because I cover them. Just because you're in a jury doesn't mean suddenly your social media is going to get flooded because nobody knows you're a juror. That doesn't get published anywhere until after the fact, and that's only if you come forward. So you don't suddenly get stuff on your social media. She said that she does mom talks and follows celebrities and like little dances. Those things are not Donna Adelson. Donna Adelson has this like complex that she thinks she's the center of everybody's universe and she's the most important person. We'll touch on that a little bit too. But yeah, no, just because they can just show the videos. She can just show, here are the videos I posted when I was a juror, like during the trial. And then they'll go, this had nothing to do with the trial. Has nothing to do with the case. And she did go over talking about how she is allowed on social media because people had mentioned, I saw on your account that you made videos during the trial. And she's like, yeah, they weren't about the case. I didn't discuss the case with anybody. And to be honest, a lot of jurors say that they don't want to discuss the case with people because it's just like when you've had a long day at work, it was a long day, go to bed. Or I just want to get food. So then, so they want to do that. Then juror number 5 appeared on Surviving the Survivor. He was the older person who came forward. He was also with the other lawyer on Surviving the Survivor podcast, where he said he considered how Miss Adelson reacted to the evidence and testimony admitted during the trial. And that's not true. That is not true. That is not what he said. He said that he was watching Miss Adelson a lot during the trial, like he was very focused on paying attention to her during the trial, and said that he did not buy her "I'm a feeble old granny" act. He said that it seemed very forced every time she was like, "Yes, Your Honor," which was only a couple times in front of the jury, or when he was talking to her, which was one of the times was when he had told Donna that she needed to put on her headphones, if you remember that part, because Donna didn't want to hear some evidence, but she had insisted that she was too, but how she looked and acted wasn't taken into evidence. That was not said. That is not true. And then the motion notes that Judge Stephen Everett told Donna that she was not permitted to show any emotion in the presence of the jury, making her appear to be cold to the seriousness and evidence in the case that may have caused the jury to believe that the defendant had no care or concern for what the victim endured, end quote. Okay, the judge had to reprimand Donna 5 times. 5 times to watch her face. The first time was during opening statements. And it was because during the prosecution's opening statement, Donna was making very blatant faces like this. She was doing that. You're not allowed to draw attention to yourself as the defendant. And that was the problem Judge Everett was having with her making faces. During the defense opening statements, she was going... She was making a spectacle of herself. You're allowed to, like, everybody makes faces, but you're supposed to remain pretty stoic and neutral for your own sake. That is to protect the defendant, because you making faces or doing things too over the top can prejudice you against the jury. The jury can see that and go, uh-huh. And that's what jurors have said in the past, that when defendants do certain things, they're like, she was acting guilty, and that bias can be put in their mind. So remaining neutral and stoic is a defendant protection. He's doing that for her. And Donna just didn't like being told what to do. But in the motion, Donna's attorney said that they want to talk to the jurors to determine whether they can confirm any juror misconduct to then make more extensive arguments about why it could merit a new trial. So they're fishing, is what they're basically saying. They're like, we want a new trial. We're fishing for ways to do that. They didn't want to speak to juror number 6. Then, separate from the juror issues, Donna attorneys say her guilty verdict should be set aside due to a number of other issues, including the credibility of the jailhouse informants who testified and lack evidence proving Donna knew about the plot to kill before Markel's death. There is no evidence that Donna did some act to assist in the commission of the crime. The jurors thought otherwise. And most of the evidence shows that she knew of the plan at some point, like the whole time. Referencing money Donna allegedly gave to Charlie to pass on as payment for the murders, her attorney said that at worst, even if Mrs. Adelson dropped off cash at Charlie's house after the murder and signed the payroll checks after the murder, would establish her culpability as an accessory after the fact, but are not competent evidence to the principle of first-degree murder. That's not for them to determine. The evidence that gets put forward is allowed to be put forward as long as it comes in lawfully. So as long as the evidence was gathered in a legal way. So like there was a search warrant, the stuff was looked through, and it was presented to the jury. The jurors are the finders of fact. They get to determine if the evidence points to her knowing about stuff beforehand or afterwards or whatever. They get to determine that, not the defense. They're really trying to go, hey, some of this stuff made Donna look really bad, and we just kind of want that to not be. But that's not how that works. The evidence gets presented, and they're sitting there going, this stuff doesn't do what the evidence says it does. The jury gets to determine that. That's what the jurors are there for. For them to say whether or not she knew to do the murders. And I'm just saying that accessory after the fact doesn't really help. As far as the jailhouse attorneys, every single one of the jurors who came forward said that they didn't give any credit to the jailhouse informants themselves, that they believed very little about what they had to say. They just seemed like they were mad that they didn't get what they wanted from Donna, that Donna made false promises and they turned on her, and that they didn't give them any credibility to begin with. The only thing that they said was that the script was written by Donna and that she at least helped make that script because they saw her doing it on the video, and then they had the handwriting expert who did it. They believed the handwriting expert to confirm that the handwriting was in the notebook was Donna's, but that they really didn't believe the jailhouse informants anyway. And the only other thing about the jailhouse informants that juror 7 did say, that juror 5 did say, the man, he said that he thought it was despicable that Donna, which went to Donna's character, was that she was willing to try to hook up Drina Bernhardt with one of the jailhouse informants with drugs when she's in recovery. Like, she's trying to get over drugs, and then Donna said she could hook her up with pills. So he said that that was despicable, and that he said that that shows the kind of person that Donna is and how far she's willing to go without any disregard. She has no regard for human life or the concern of other people, just getting her way. Donna's attorneys argue in the motion that the prosecutors base their entire case on speculation, impermissible stacking of inferences and theories. No, when you have a circumstantial case, that's what you do. It's not speculation, it's circumstantial evidence. And they said that they're not allowed to stack those things up, and they are allowed to present the argument and let the jurors decide if they agree with that argument or not. Which was already discussed in motions in limine. They tried to have this done before. It didn't work. It's not going to work now. And they pointed to the courtroom itself as a reason why their client was convicted. The defense pointed out to moments where the courtroom gallery laughed in response to rulings from the judge and reminded Judge Everett that he had to admonished spectators on more than one occasion. We're going to go back to, he had to admonish Donna Adelson 5 times in the trial, okay? Including right after the first verdict was read. He said, Miss Adelson, control yourself. And he always excused the jury before he did. And so all of the rulings that were made with the jury out of the courtroom. And he had to tell the gallery twice. He told the gallery twice that they were to also remain neutral and to not have any expressions that could be biased one way or the other, or they would be excused, that they were to try to control their emotions no matter what was put on the screen. And the other time that he didn't really admonish the gallery, he warned the gallery before the jury came back with the verdict and they were allowed back in. He said that there is to be no cheering, no clapping, no booing, or you are to remain neutral no matter what the verdict was, that they are not to express speculative emotion. So that is an interesting reconstruction of what happened. Saying that he had to admonish the spectators on more than one occasion. Yes, he did have to technically tell them once to keep their emotions neutral. And then he also he warned them. So that's taking that way out of context. Not only were they laughing out loud, there were some times when the judge did something charming and the gallery went and they said they were laughing out loud. Videos and images captured throughout the live video casting revealed Gallery making faces and moving about to capture the attention of the jury while the testimony was underway. That's not true. That is not true at all. I would just like to say that the defense had intentionally also made jokes while they were doing stuff, and the gallery and the judge and people gave appreciative laughs when she was trying to make a joke. So she did that. Sitting there saying they were laughing out loud at stuff you said, defense, that you were trying to do. She was trying to, Jackie, she was trying to appear charming to people as well, because juries they'll judge a lawyer and be like, how you doing? She was trying to appear lighthearted and stuff as well. And moving about to capture the attention while the testimony was underway. There were times where where people in the gallery got up to go to the bathroom or to check their phones, because they're not allowed to have their cell phone use happening in the courtroom. So, do people occasionally get up and leave? Yes. But there was also the fact that they had 2 people sitting in the jury from their witness list listening into other testimony. And the judge had admonished them twice about having his sequestration order broken. So why don't you bring up that you broke that a couple times back to back? Well, I guess technically it was once, then not, then again. The motion accuses Judge Everett of favoring the prosecution throughout the duration of the trial, giving them extra time to set up for electronics and joking with the attorneys about it, while also denying Donna's request for additional time to weigh whether or not she would testify. Stop. No, we do not. Okay, first of all, the prosecution had 2 days of electronic phone calls, the bump evidence, and surveillance footage. Okay? So it does take time to set that up. They weren't given extra time. They were given the same amount of time and allowance, which was, all right, so get that all set up. This is what the judge had said. Get that set up, let us know when you're ready, and then we can bring the jury in. The defense for their electronic digital forensic witness was given the exact same thing of, okay, get set up, let me know when you're ready so we can bring the jury in. They weren't given extra time to set up electronics. They weren't given any additional time. We had the fewest amount of breaks in the entire first 8 days of trial. For the prosecution's defense, we had almost no breaks. It was very straightforward, boom, 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 boom. The 2.5 days of the defense case was mostly them saying, hold on, we need a moment, Your Honor. And I had mentioned that in my summary, that they had most of their time was figuring out what they were doing. And also that they were denied Donna's request for additional time to weigh whether or not she should testify. That's because it was over a 3-day weekend. They had been saying the entire time in other motions and filings and housekeeping before and after the jury came in and left, the defense had been saying, well, it's because we're going to have our defendants probably going to testify. Our defendant's going to testify. They were saying that they were absolutely saying things that indicated that Donna was already planning on going up on the stand. And then the prosecution rested their case on a Friday, the Friday before Labor Day. Monday, September 1st was the holiday. So they knew that their case in chief was coming up. So they had 3 days, Saturday, Sunday, and Monday, that they could have been discussing and going over stuff with Donna. The fact that they did not use their time effectively is not Judge Everett's fault. And the judge pointed that out to them, that there is always time over previous weekends that they could have been bringing up her coming onto the stand, that they had referenced bringing Donna onto the stand as if it was already confirmed for that. And then they had a 3-day weekend to discuss it, and they didn't have any other witnesses to bring up. So Judge Everett asked them if Donna was going to take the stand, if Miss Adelson was going to take the stand. And they said, well, we need more time to confer with her. And he was like, you got 5 minutes. You had a 3-day weekend. He didn't say it like that, but he said, given the extended weekend that we just had, you should have had ample time to already discuss this. Not to mention, you knew that this time would come up sometime during the trial. You had other days that you could have discussed this. The fellow defense attorneys commented that they had appeared before the court on trial on similar charges and were shocked to see the obvious disdain that the court showed towards Miss Adelson and her counsel in this case. Donna is due to return to court for a status conference on October 4th. Her sentencing has not been scheduled. To my understanding, her sentencing is actually on October 14th. And it doesn't matter. I guess it's just because of the motions that are coming forward that's now been changed to a status conference. But October 14th was originally placed as her sentencing date. And she's got life. Because once you're charged with first degree, there isn't anywhere else to go in Florida. It's just life. That's it. I came across that and read the article. And I was like, are you peaching kidding me? No. No, you're not. Get out of here. The jurors were presented evidence that both sides had access to. They were all given ample time. In fact, the judge gave the defense lots of extra time, and judges often do. If the prosecution had an expert witness who had a non-approved expert witness violate a sequestration order, he would have thrown it out. But he let her come on the stand because it was the defense. And so, and who are these other supposed defense attorneys who commented? Like, let's see their comments. Come forward, other defense attorneys who have been in front of Judge Everett, who said that there was obvious disdain. Who are you? Show yourself. Reveal your lies. Crazy.